some important features of a government list. In this section, then we'll focus on how list is being operated, in the private sectors. That means after government has granted the list to the lessee, how would that lessee make use of the property by using a private lease. Now, first of all, some terms. Lease tenancy basically means the same thing. Of course, if you are talking about the document itself, we always use the word lease. Tenancy itself is the concept, but as a legal interest, lease and tenancy basically means the same. And well, again, there's a usual practice. If we are referring to a tenancy of long duration, then we usually call a lease. A tenancy is basically reserved for a lease, under 5 years or so. But of course, this is only a matter of practice. It does not mean that if you refer to a term more than 6 years, you could not use the word tenancy. So, lease and tenancies share the same meaning. Remember, not temperament, set in street and Mumford. There are 3 elements: rent, fixed term, and exclusive possession. So basically, it is an agreement. If we are talking about private tenancy, it's an agreement whereby a landlord, in Hong Kong, of course, the landlord is really a tenant, agrees to give exclusive possession. It must be, this element of exclusive possession must be there in order for that legal interest to become a lease or a tenancy. So give exclusive possession of the property to a tenant, or in Hong Kong, actually subtenant, because the so-called landlord is himself a tenant, is a lessee, for a fixed period of time. That is the terms in here, absolute, fixed term, fixed beginning, fixed end. In exchange of a rent, of course, even though the the English Court of Appeal in a later case said rent is not a must, but in practice, if we are talking about private tenancy, there is almost always the element of rent. The tenant has to pay a rent in exchange for the exclusive possession of the property during a fixed period of time. And after we have defined, of course, we learned that already, a lease must contain a fixed term. Immediately we have something look like an exception, but actually not really an exception. This is the concept of periodic tenancy. Well, in theory, you may have a lease. You may agree, the landlord and tenant agree to have the lease to be automatically renewed. Once the period, the fixed term expire, the tenancy will renew by itself for a fixed period of time, and we call that a periodic tenancy. And periodic tenancy can be granted by grant. That means when the landlord grants you the lease, he immediately said that, well, okay, this is a 1-year tenancy, but unless we notify each other, the tenancy will be terminated at certain time, then this tenancy can be renewed forever. Now, it is not really talking about an indefinite term. The term is still 1 year, but it can be renewed automatically. It is on top of the concept of a lease when you have a periodic tenancy, an agreement to renew the lease by itself. Now, so when you create a lease, you immediately create a periodic tenancy. That is one way of doing that. But the more usual way would be by invocation of law. That is to say, again, it is a kind of practice that is recognized at all as creating a periodic tenancy. For example, if a tenant is in possession. Now, by now you should know the word in possession has a special meaning in land law. It means this guy has an exclusive possession and pay rents by month. Okay, pay rents by month. Then we can say a monthly periodic tenancy is implied. Don't have to say. You can, by conduct, pay monthly rent, and you have the exclusive possession. Then and there is no agreement as to how long this tenancy would last. You know, the law would imply a monthly periodic tenancy being created. So as long as you have exclusive possession, always remember exclusive possession is the most important element for the existence of a lease. Then we may, from that point onward, and see whether there are other elements to make this right to have exclusive possession in relation to a property could create a lease or not, or if it is a lease, whether it's a fixed term or periodic tenancy. And another way to imply a periodic tenancy is when. Now, after a tenant occupied a premises under a normal lease, for example, 2 years duration, but after the expiry of that 2 years, the tenant remain in possession, still stay in that property, and he pays rent on a periodic basis. Now again, he pay rent for staying in that property, monthly rent in most cases, and we can imply a monthly periodic tenancy being created. And remember, this period, when we say periodic tenancy, the period is counted on the way in which the rent is computed, how to compute the rent. Then the period is actually referred to that length of time, but not on the way it is actually paid. So you can agree with the landlord to pay him half yearly, or just like in England, I don't know whether you have read it on newspaper about the practice when some Hong Kong BNO holders immigrate to or move to England. I don't know whether they are really immigrating. They are looking for some flats or some house to live, and the landlord require them to pay half yearly the rent, or the complete rent for 12 months. Now, but it does not mean that the lease is for 6 months or 12 months. It may still be monthly tenancy, but just like the concept of periodic tenancy, we are talking about if you are talking about monthly rent or half yearly rent, then the period would be a month or 6 months. So each period is a fixed term of the tenancy for periodic tenancy. So monthly periodic tenancy means that the fixed term of the tenancy is a month. But this fixed term can be renewed automatically. And this periodic tenancy in theory can continue indefinitely, period after period, month after month. It is a monthly tenancy until a notice to quit is given by one party to another to terminate this periodic tenancy. Now, by one party to another party. That means both the landlord and tenant can serve this notice to quit. So if the tenant wants to leave, he can serve a notice to quit to the landlord. Likewise, the landlord can, in a way, terminate the periodic tenancy with one particular tenant by serving him a notice to quit. Now, there is some kind of legal principle to follow for terminating a periodic tenancy. You cannot just say, oh, I serve you a notice to quit, then you have to go tomorrow. It is not the case. You must have a period of notice for the notice to quit, to serve the notice to quit. So, if, as we said, each period is a fixed term. If the fixed term is less than a year, so for example, monthly tenancy, 2 months tenancy, 3-month tenancy, up to 12-month tenancy, one full period of notice is normally required, particularly if it is less than 6 months. In other words, you pay the rent for this month if you are talking about monthly tenancy. If you are the tenant, you have to, at the same time, serve that notice to quit to the landlord to say, oh, that is my last month. Give him a full period. If the period is 6 months, then you have to serve this notice to quit 6 months prior to the date you want to leave the premises. And if it is a yearly tenancy, 12 months, the notice of quit must be served at least half of a year, 6 months, before the expiry of the end of that year. Normally, we do not have periodic tenancy that has a period more than a year. Well, of course, in theory, it could exist. Now, so periodic tenancy, in a way, look like an exception to the requirement of fixed term. And there is actually a real exception to the requirement of fixed term in a tenancy, which we call that tenancy at will. Now, tenancy at will is not a real tenancy. It arises when a tenant occupies the property or land with the consent of the owner or of the landlord under a tenancy of uncertain duration. Now, by definition, you must have a certain duration of tenancy. If it is an uncertain duration, in fact, that is not a real tenancy. So, in fact, each party may at any time terminate the arrangement at will. Anytime you feel you want to go, then just tell the landlord, I'll go tomorrow, because this is at will. That means you can do whatever you like. So tenancy at will is not really a tenancy. It's similar to a license. And the main difference is that if you are a licensee, usually you would not have exclusive possession of the property. But when we describe that legal right to the property as a tenancy at will, it means that the occupier has exclusive possession. And in our technical term, the tenancy at will, under tenancy at will, the tenant is considered to be in possession of the land, exclusive possession. Whereas a licensee, the one who obtained a license, is normally not in possession of the land, because the licensee's right is not a proprietary right. Now, just refresh your memory about the second lecture. Under the CPO, Conveyance and Property Ordinance, all agreement in relation to land tenancy, sale and purchase agreement, etc., must be in writing. But there is an exception. Any tenancy which is less than 3 years in duration, fixed, best obtainable rent or market rent, and exclusive and without premium, can be created orally, right? There is an exception for the requirement of writing for some proprietary rights to be created. And in Hong Kong, however, particularly in commercial or domestic tenancy, usually the duration is less than 3 years. Yet, solicitor would be engaged by the landlord or by the tenant to prepare written tenancy agreement. I don't know whether you are now, renting some premises yourself as your home, and I guess you would have signed a written tenancy agreement. Or in fact, it's not required to do that because unless your rent is not marketable rent, I would believe that it should be. If that's the case, then it falls into the exception, and no written tenancy agreement would be necessary. And in fact, we are going to study this particular rules when we discuss the land registration ordinance. Even it is written tenancy, if it is less than 3 year duration, it is not required to be registered under the land registration ordinance. Now, of course, there are mainly two reasons for written tenancy agreement to exist. Not for protecting the interests of parties, so because under our ordinance, landlord and tenants consolidation ordinance, all the rights and obligation of landlord and tenants are already implied. So you don't have to say anything. Just say, oh, okay, I'll rent you this flat for 2 years. As long as it is marketable rent without premium, everything is settled. You don't have to worry. Well, what about this tenant use my premises for illegal purpose? Can I terminate the agreement? Yes, you can. Later on, we'll see what are the law being implied in all such tenancy. So the first reason is not really to protect when we have written tenancy. The reason is, number one, is for the solicitor to earn money. Okay? Particularly when the landlord is a company or they have a lot of different premises, they would say, oh, I'd rather to have a ease of mind. So I hire a solicitor to represent me and draft a tenancy agreement. In fact, except that you have a very peculiar condition you want to impose on your tenant, that is really no need to have a written tenancy agreement. So number one is for lawyers to earn money. Number two is for the landlord to, put up certain, how should I describe that? To put up some kind of, camouflage. What's camouflage? Some insects, when they rest on some trees, the color will change so that nobody can see them. That is a kind of camouflage for the landlord to pretend that the tenants has a lot of obligation to shoulder, but in fact all those obligations already exist. And from the practical perspective, if you are a solicitor or you are a legal executive, from time to time you will be asked to draft tenancy agreement. But in reality, most, or I would say all solicitor firms would have their own precedent for tenancy agreement. And all those tenancy agreements would spell out the rights and obligations of landlord and tenant. And in most cases, this tenancy agreement tends to be more in favor of the landlord than the tenants. Now, in reality, these are the four factors that must exist in a tenancy agreement in Hong Kong. I'm talking about Hong Kong. You only have to spell out the parties, landlord and tenant, the property, of course, the property to be rented by the landlord to the tenant, the duration, commencement and termination of tenancy, and also the rent, of course, including other consideration for the tenancy. That would, in most cases, adequate. And now, if you hire an estate agent, no matter you are a landlord and tenant, they would require you to sign a preliminary tenancy agreement. But in those cases, it must be ensured that all the four elements would appear in the preliminary tenancy agreement. Otherwise, that preliminary tenancy agreement would not be enforceable. But I don't think there should be any problem, because nowadays the estate agency, particularly the major field, they have already pre-printed copy of such tenancy agreement, which has been settled by experienced lawyer. Now, as I said, there's no need for a written tenancy agreement because all the obligations of landlord and tenant are implied by law in Hong Kong. Now, for landlord, there are only two implied obligations. And if the landlord is in breach of any or both of these two implied obligations, the tenant would have the right to terminate the tenancy. And these two implied obligations are implied covenant. Well, for quiet enjoyment, an implied covenant ought to derogate from his grant. Of course, covenant here just means agreement. Now, the first obligation, quiet enjoyment, actually has to do with the concept of exclusive possession. In order for a tenancy to exist, the tenant must be given exclusive possession of the property during the tenancy. And therefore, the tenant is entitled to have quiet enjoyment of the property. And quiet enjoyment actually means the landlord cannot interfere with the lawful use and enjoyment of the property by the tenant, as long as the tenant uses the property in a lawful manner. The landlord has no right to interfere. So in fact, quiet enjoyment is the other side of the same coin of exclusive possession. Classic example of breach of quiet enjoyment is this case, Kenny and Pree. Now in this case, the landlord and tenant enter into a tenancy, and the landlord claimed that the tenant is in breach of the tenancy and served the tenant a notice to quit. And after serving the notice to quit, the landlord sent letters to the tenant, asked her to leave, shouting at the tenant and banging on her door, asked her to leave. And even when the tenant was away, the landlord broke into the premises and removed the tenant's belongings from the premises on the ground that he has already terminated the tenancy. But you cannot normally terminate the tenancy prematurely without the order of the court, even though the tenant may have actually committed a breach of condition. So at the end of the day, when the tenant sued the landlord for breach of quiet enjoyment, the court agreed the landlord was in breach of the covenant for quiet enjoyment, because during the tenancy and until it is terminated, the landlord cannot interfere with the lawful use of the premises. If the tenant just stay there doing nothing illegal, the landlord cannot, cause all this trouble to the tenant. Now, in Hong Kong, we actually have a very even more dramatic kind of breach of quiet enjoyment example. Now, this is a case about, some security of tenure cases. If you remember, in the old days, in fact, the law still exists, even though the land under this Part 2 of the Landlord and Tenants Consolidation Ordinance almost disappeared in Hong Kong. But if your land, if the premises is built in land, classified as Part 2 of the Landlord and Tenant Consolidation Ordinance, usually refer to some building which exists even before the Second World War. Now, the tenant in those premises would be protected by this Landlord and Tenancy Consolidation Ordinance, and they can have security of tenure. That means they can stay in the premises as long as they pay the rent. Now, what happened in this case is that the landlord wants to redevelop the entire building from a domestic building into a commercial building. So he tried to negotiate with the tenant occupying different units of that building. But only this Mr. Yeo, insists to stay. Because he understands that there was no more Part 2 property in Hong Kong. So that is really a valuable kind of asset. But unfortunately, this guy got a job to work in Beijing for 1 year. And 6 months or so after he returned to Hong Kong, he found himself unable to enter his own premises because the lock has been replaced and that his premises were under major renovation work. And after completion, the building had become a commercial building and no longer suitable for residential purposes, because all the walls have been locked down and replaced by glass panel. It is not possible for you to live in such a condition. So he sued the landlord for this breach of the covenant for quiet enjoyment. And in fact, the court find that the action of the defendant went beyond mere breach of the implied covenant for quiet enjoyment, because he totally disregard the protection given to tenant under the Part 2 of the Landlord and Tenants Consolidation Ordinance. So, but he has made such a change it is impractical to reverse the commercial building back to the old domestic building. So as a result, the court award the plaintiff, the tenant, both damages, that is for the breach of quiet enjoyment, and exemplary damages. Now, exemplary damages are usually awarded as a kind of punishment to the party. So it is a kind of punishment for the landlord's disregard of the protection under Part 2. So that is about the obligation for quiet enjoyment. And for the other obligation, not to derogate from the grant. Now, grant, of course, it means to give out the tenancy, grants the tenancy. Not to derogate from the grant means that landlord cannot do anything to defeat the tenancy that he grants to the tenant. He cannot grant a tenancy to a tenant and then do something to make it impossible or very difficult for the tenant to enjoy the premises. Now, the definition can be found by this judgment of Justice Parker in Brown and Flower. The lessor, that is the landlord, has done or proposed to do something which render or would render the demised premises, demise means rent, the demised premises unfit or materially less fit to be used for the particular purpose for which the demise was made. Demise, well, as a noun, refer to the tenancy. So, you are doing something or propose to do something which make the purpose of renting the premises either unfit or less fit. Now, and in a recent Hong Kong Court of Final Appeal cases, Lord Hoffman, sitting as one of the non-permanent judge, he explained this principle of non-derogation from grant. He said the principle is based upon the presumed intention of the parties. That is to say, when the landlord and tenants enter into the tenancy agreement, the tenant, well, of course, in most cases now in Hong Kong, the landlord would ask, what is the purpose of the tenant for taking up the premises? Say, for example, if it is commercial tenancy, the landlord would ascertain what kind of business you want to carry on in that particular premises. And then he or and the landlord would then decide whether or not to grant you the tenancy. So what Lord Hoffman is saying is that now if the landlord agree to grant the tenancy after learning that the tenant's purpose is to, say, run certain business in the tenancy, then the court will presume that the landlord allow or at least agree the premises to be used in the way the tenant intends it to be used. And then he could not therefore do something to defeat the purpose of the tenant. And there is another description of this concept, exercise of determining extent of the implied obligation not to derogate from the grant, involve identifying what obligation, if any, on the part of the grantor, that is the landlord, can fairly be regarded as necessary implicit, having regard to the particular purpose of the transaction, which consider in the light of circumstances subsisting at the time the transaction was entered into. Again, it also described that when the parties, grantor and grantee, landlord and tenant, enter into this tenancy agreement, what the grantor, what the lessor or grantor has explicitly or implicitly agreed that the premises has to be used. Now, if the concept is difficult to understand, an easy way to understand it is this. Typical scenario, in fact, of derogating from the grant is when a landlord grants a tenancy to a tenant to carry on certain business in his premises. The landlord then creates some impediment that prevents the tenant from carrying on the particular business in the premises. Example, I agree with my tenant to allow him to run a restaurant in the shop I own. But I own the shop adjacent to that shop. I run a garbage collection center. Now, of course, garbage collection center would create both problems in terms of hygiene, the odors coming out from that collection center must make the restaurant unfit. I mean, the shop unfit for restaurant. Now, if that's the case, I am derogating from my grant to that tenant when I rent the premises for him to run the restaurant. Now, a recent case in England, even though it is 20 years ago, illustrates the point of derogating from the grant. Now, we are talking about a list of a gift shop in connection with the London Aquarium at the Riverside building. Now, the owner of that building rents a shop premises to the tenant to run a gift shop under the list. It expressly said that the shop is going to be used for running a gift shop. And it also contained a covenant, an agreement by the landlord, not to permit any other gift shop to be operated in the building. Of course, confining to the gift in relation to London Aquarium. Now, And in the premises, in the tenancy agreement, it only said in the building, and there was no definition in relation to the extent of the building. Does it only confine to the building, or it include the passages leading to the building? There is no such definition. Now, between that building, Riverside building, the facade of the building, and the river wall, there was actually a walkway, and that part is called Queen's Walk. Now, the landlord, after granting the tenancy to the tenant to run that gift shop, he then proposed to erect 2 kiosks, some kind of stands, temporary stands, or for selling something on this Queen's Walk, and use them for the sale of gift items, and such gift item including items relating to the aquarium. So the tenant said, now you grant me this tenancy, and you also agree that we have the exclusive right to sell gift items in relation to aquarium. Now, you propose to erect these 2 kiosks to sell the same item. It is a breach of that covenant not to derogate from the grant. And the landlord said, the covenant only said in the building. Now we are talking about the walkway leading to the building. It is not in the building. So that is basically the crux of that dispute in relation to this case. And of course the tenant said, well, even though you say in the building, it must include the walkway, which should form part of the building. Now, that case was heard by Nicholas Warren QC, sitting as the deputy judge of the Chancery Division. He held that the walkway itself did not form part of the building because, building, of course, is so clear, the word is so clear, it would not refer to the walkway. But for the use of the proposed kiosk to sell the aquarium-related items would still be in derogating of the landlord's grant, because if you go back to the definition, of Justice Parker, would that new proposal would render the demised premises, that the shop, unfit. Of course, it's not really unfit, but material less fit to be used for the particular purpose. Because now they do not have the exclusive right to sell the souvenir of the aquarium. Now, this obligation not to derogate from the grant is an implied obligation. That means if you do not say anything in relation to that, this obligation will be implied in your tenancy agreement. Therefore, in many tenancy agreement, written tenancy agreement of commercial premises, there is usually an express clause whereby the landlord makes no warranties that the property is suitable for the intended use of the tenant. Now, once you have an express term, then the implied obligation could not be implied. And in fact, that is how the landlord try to escape from this potential liability for derogation from the grant. In fact, this is another reason for written tenancy agreement to be drafted by the landlord to absorb their liability from the tenancy agreement. And there are many forms of derogation from the grant. In fact, in my practice, I came across a case in which a shop is rented to a tenant for running a Japanese restaurant. Japanese restaurant selling sushi, sashimi, and I have no such, concept before. In fact, if you want to run a Japanese restaurant as such, it requires that the air conditioning system for the shop must provide cooling effect up to a certain degree. Otherwise, the Japanese restaurant cannot be run. The sashimi or the sushi would easily become contaminated. And in that case, in fact, the landlord of the shop has no control of the air conditioning system, because the air conditioning system is centrally controlled by the entire building, the manager of the entire building. But at the end of the day, because the temperature provided by that central air conditioning system is considered to be too high for the purposes of running a Japanese restaurant, the landlord was found in breach of this obligation not to derogate from the grant, even though in fact he has no control. And he has to pay compensation to the tenant for the entire terms of that tenancy agreement. So this could be would carry serious consequence. And therefore, in fact, nowadays in most cases, the landlord would have this express provision inserted in the tenancy agreement to disclaim any liability. They would say we will make no warranties that the property is suitable. In the previous example, if that landlord has hired a competent solicitor to draft the tenancy agreement, the solicitor would have said, insert in the tenancy agreement something like the landlord makes no warranty that the shop is suitable for running a Japanese restaurant, something like that. If that's the case, then they can escape from this implied obligation. Now, and in most written tenancy agreement, if you are, renting a premises, you can pick your tenancy agreement out and read it. There are a lot of expressed agreement, expressed covenant. For example, the tenant cannot assign, sublet, or part with the possession of property, or they cannot, use the property for illegal purposes, etc. Now, if there is no such express provision, in fact, the tenant would have the following implied obligation, implied by different ordinance. For example, there is a statutory obligation to pay rates on the part of the tenant. I don't know if you are aware of it or not, because now in Hong Kong, the practice is that the landlord would pay the rates. What they say, 全包. The rent will include rates and management fees. Well, in the old days, in fact, both the rates and the management fee would be paid by the tenant. But since it is only an implied obligation, therefore, landlord and tenant can agree that it would be the landlord who pay the rates instead of tenant. If there is no such express provision, then under Section 21, subsection 1 of Rating Ordinance, it would be the duty of the tenant to pay rates. And there are other obligation implied in the Section 117, subsection 3 of Landlord and Tenant Consolidation Ordinance. Now, there's an implied obligation to pay rent on due date. And if you look at your tenancy agreement, you will see there is an express provision that the tenant has to pay rent on the first day of the month, etc. In fact, it's not necessary to say that because there is already an implied obligation. Implied covenant that the tenant not to use, suffer, or permit the use of the premises for any immoral and illegal purposes. Now, if you read your own tenancy agreement, you will find that there is an express provision saying the same thing. Again, it's not necessary to say that because it has been implied under this section. Implied covenant that the tenant not cause unnecessary annoyance, inconvenience, or disturbance to the landlord or to any other person. Again, this is a common clause that you can find in a written tenancy agreement. Again, not necessary to say it out because it has already been implied. Implied covenant that the tenant not to make any structural alteration without the prior written consent of the landlord. Again, if you look at your own tenancy agreement, if it is particularly if it is drafted by a solicitor, you can find exactly word for word. Of course, there is no implied covenant. Tenant agreed not to make any structural alteration. So you think it is really a fool. You are really a fool to pay it, the solicitor to copy something from the ordinance. A condition for forfeiture, if there is any implied covenant mentioned above, is broken. Forfeiture means you can terminate the agreement before the term of that tenancy expires. And there are other implied covenants, such as the tenant has to use the premises in a tenant-like manners and carry out minor repairs, and permits the landlord to enter the property to inspect and repair. This is important because tenant has the exclusive possession, so the landlord cannot enter without the permission of the tenant. And just in case there is some repair that need to be done, but the tenant refuses to carry out, the landlord preserves possession to enter the property to carry out the repairs. Implied covenant to deliver vacant possession at the end of the tenancy in good shape, fair wear and tear expected. If you look at, if your tenancy agreement is drafted by a solicitor, you can find word for word being copied in that tenancy agreement, of course, without the word implied. So, if you are a landlord, you have some property, you want to rent it out. So it's really not necessary to hire a solicitor to prepare a written agreement, unless you have some special rights to protect, just like in a commercial premises situation, you want to avoid the obligation not to derogate from the grant. Then, of course, it would be helpful to have a written tenancy agreement. Otherwise, it's all the obligation were being implied already. Say it out or not say it out does not make any difference. But if you choose to prepare a written tenancy agreement, then there is a further obligation that you have to observe. That is to stamp that agreement. You have to go to the race department to get the tenancy agreement to stamp. Because, in most cases when you want to have a written tenancy agreement is when there is a dispute. You have to go to court. Then the written tenancy agreement, of course, would contain all the right and obligation of the landlord and tenant. If you do not stamp this tenancy agreement, then it cannot be produced as evidence in court. Then why you want to prepare a written tenancy agreement to begin with? Therefore, if you choose to have a written tenancy agreement, remember, always stamp that tenancy agreement. And usually it is within a month. If you stamp it later, well, what about when there is any dispute, I take that tenancy agreement to stamp? Yes, in theory, you still can do that, but you have to pay a fine. The stamp duty is much, much higher than it should have been if you time it within the first month of the tenancy agreement being prepared. Now, we have also mentioned about the security of tenure being being terminated by Mr. Donald Tsang's government. It was actually abolished on the 9th of July 2004. That is about a year after the SARS attack in Hong Kong. Now, before that, it could be tricky because due to the provision of security of tenure. In the old days, tenants were still able to remain in his possession of the property even though the tenancy expired. If the landlord failed to give notice to quit in accordance with this legal provision of security of tenure, and even if the landlord had done it correctly to serve the notice to quit on time, that tenant still would be entitled to have the tenancy agreement renewed as long as he is willing to pay market rent. But all those provisions have been repealed now, by this particular ordinance. And no security of tenure whatsoever is applicable to any domestic tenancy agreement entered into or after the 9th of July 2004. So in fact, it would include all domestic tenancy. I won't expect you would have a domestic tenancy more than, say, 17 years. In Hong Kong, all tenancy, domestic tenancy would only have a duration of 2 or 3 years or so. And I would not believe you would have a tenancy which has a duration more than 20 years or 10 years. Therefore, I would say now no domestic tenancy in Hong Kong would enjoy any security of tenure as a result of the change of law in 2004. Now, in the past, if you want to terminate a tenancy agreement upon its expiry, you have to serve a notice to quit. Now, since this day, that 9 of, well, I'm sorry, it should be July. Well, yeah, July, I'm sorry. 9 July 2004, you do not need to issue a NTQ, notice to quit. Instead, you have to serve a, well, transitional termination notice. Now, it has been transitional for so many years. And this transitional termination notice means a written notice of termination. And there is some rules that you have to follow when you want to serve a transitional termination notice. If it is served by landlord, meaning the landlord wants to take the property back, it has to be served not less than 12 months from the last day of that tenancy. If it is by tenant always has better treatment, not less than 1 month before the day in which the notice, the transitional termination notice is to take effect. So that is the normal way to terminate a tenancy agreement. When it expires, before the tenancy agreement expires, the landlord serves this transitional termination notice to you. But I know, in reality, because security of tenure is no longer available, not many landlords would have served this transitional notice, termination notice to the tenant. Likewise, the tenant would not serve the transitional termination notice to the landlord. And they would just leave the premises upon the tenancy agreement expire. Now, tenancy agreement is after all a contract. So, if either party commit a breach of condition, that the innocent party can terminate the tenancy. Of course, from the perspective of a tenant, the condition for a tenancy is, of course, to pay rent. So if a tenant fails to pay rent timely, that would be a breach of condition, and the landlord can terminate that tenancy agreement. And in fact, if you have a written tenancy agreement, one of the uses to provide a written provision under which or whereby the landlord may forfeit a tenancy. And after forfeit, of course, the landlord can re-enter the property, when the tenancy is in breach of certain condition. And we usually call this provision about how a landlord can forfeit a tenancy, forfeiture clauses. And again, it is not just a matter of contract, because a tenancy is subject to the landlord and tenants consolidation ordinance. And under that ordinance, if you want to forfeit a tenancy agreement, you have to follow the requirement of Section 58 of Conveyancing and Property Ordinance. And this section requires the landlord to serve a notice to the tenant first. Now, he has to do 3 things in this notice. First of all, specifying the particular breach. For example, tenant failed to pay rent on time. If the breach is capable of remedy, now in our example, if you pay back the rent, okay, then you have to require the tenant to remedy the breach. You will say, now you are in 3 days, you are 3 days in arrear of the payment of this month's rent. Please settle the rent within the next 3 days or next 7 days. give him a way to remedy the breach. And the last thing, specify the compensation which the landlord requires in respect of the breach. Now, so 3 days in arrear of the rent, and please settle the rent within the next 7 days and pay me interest for this 10 days or something like that. You know, you have to serve this notice to the tenant. If the breach is capable of being remedied, you would allow him to remedy. If there's some breach which is not capable of being remedied, of course you don't have to give him a chance to remedy the breach, but you can always specify the compensation if you want to continue with the tenancy. If not, then you can just say, well, you are in breach of certain condition, and because of that, I want to serve you this notice to terminate the tenancy agreement under which particular clause of the written tenancy agreement. And if the tenant fails within a reasonable time to remedy the breach, reasonable time would, if you do not specify a time, if you specify a time, then you can also say, if you fail to settle the rent within the next 7 days, remember always add time is of the essence, then the landlord would be entitled to forfeit the tenancy. That is to say, the tenancy would be determined. Remember the words I talked about last time? The word determines, when used in the context of a tenancy, it means terminate. Now, even though you say you have forfeited the tenancy, you cannot just re-enter by, changing the lock of the premises. You still have to go to court to get the court order. Otherwise, you may have committed a criminal offense. But one more thing to remember, say for example, the example I gave earlier, tenant failed to pay rent. Then, of course, you would require him to pay rent until he leaves the premises. But this is a pitfall there. Even if you want to get the rent, you can no longer refer that amount of money as rent. Because once you say, in the meantime, please pay me the rent from which day to which day, that would be considered as, by the court, that you do not want to terminate the tenancy. Because, rent is one of the elements of the tenancy. Therefore, it does not mean that you have to give up your right for the rent. You have to use another word. This one, means profit. You would require the tenant to pay means profit for the occupation of the premises particularly after the forfeiture. Because tenancy has already terminated, the fees to occupy the premises is no longer rent. It's only when the tenant is occupying your premises under a tenancy that you will ask him or her to pay a rent. So this is also something important. But of course, if you are a lawyer, you would not make such a mistake. Because once you require the tenants to pay rent, it would be considered as the landlord waiving the breach. Now, if you have waived the breach, that means the tenancy still continues. And if you want to terminate the tenancy again, you cannot rely on the same breach. You have to wait for another breach committed by the tenants. So you always use the word means profit instead of rent. Of course, just like the government list, tenancy agreement can also be terminated by surrender. That would be a case in which the tenant give the vacant possession of the premises to the landlord, and the landlord agrees or accepts such surrender, and the tenancy determines. There is no special rules for effecting surrender. Surrender can simply be effected by tenant giving up the possession and returning the keys of the property to the landlord. Now, but if the landlord does not accept surrender, he can still get the keys back and get the possession back, but the landlord could still sue the tenant for the rent of the remaining term. Now, there is one more possibility for the tenancy agreement or tenancy to be terminated. It is when the tenant purchases the property from the landlord during the tenancy. Now, this is called tenancy terminated by merger. The right of the tenant merge with the right of the landlord, because the tenant now becomes the landlord. And there could also be tenancy agreement can also be terminated by the tenant commit a repudiatory breach. For example, premises are expressly let for domestic use, but the tenant converted into commercial use. That would also allow the landlord to terminate the tenancy. And of course, there is one final possibility, terminated by frustration. But you should remember your case law in your obligation lecture. Even in theory, tenancy or lease can be terminated by frustration, but it could only take place in rare situations. There is the case, National Carrier. It is about the lease for 10 years, but then within those 10 years, the only access to the premises has been closed down by the local government for 21 months. But even in that situation, the House of Lords refused to hold the lease, having been frustrated. Now, so that's all about tenancy or lease. Now, we just very briefly talked about license. License, again, remember this is not a proprietary right. It is a right to occupy certain land or enter certain land, and it is a personal right. In most cases, it is a contractual right. There are 4 kinds of licenses altogether: a bare license, license implied by interest, a contractual license, and a license by estoppel. Now, no matter which category of license, there is one common theme. A license is generally revocable. That means I grant you a license and I can always revoke it, unless this license is coupled with a proprietary interest in land or proprietary interest in chattel. For example, customer of a supermarket is entering the supermarket with an implied license, but this license is limited to permitting the customer to view the merchandises and to purchase those. And the owner and his agent can always terminate his license and invite the customer to leave the supermarket. And you cannot argue with him. I still want to purchase something. He can just say, "Oh, I don't want to do business with you. Please leave. You have to go." Now, what about when we go to cinema or theater? We have a ticket. Now, if you have a ticket to enter those theaters or other premises, football pitch, etc., it is a contractual license. And you holding ticket is a contractual licensee, and you have no right or interest, no proprietary right in the land in question. Now, if you have a contractual right to back you up, then your position would be much better than a bare license as being a customer entering a supermarket. And the court's approach, the modern approach, is that as long as the ticket holder behaves, do according to the rules of the premises, he's entitled to stay in the theater or football pitch until the show's finish. And in fact, in the past, even the contractual licensee could be kicked out any time. Of course, if it is possible, even though in practice it may not, you got a contract, you can ask the court to grant you an order for specific performance. So if the landlord does not allow you to enter, or licensor does not allow you to enter the premises, you can go to court to ask for specific performance. So of course, it is not impractical. It is impractical because it takes time for the court action to take place. Now, in a recent case in England, Manchester Airport and Dutton, the English Court of Appeal held that a contractual licensee was entitled to bring the proceeding to eject trespassers, even though the licensee have not yet been in possession of the land. This is an interesting case. It is about the building or extension of the Manchester Airport. And there are many environmentalists who are opposed to that project. So many people try to occupy the land, intended for extension, and to stop the builders, construction worker to enter the premises, because such protesters are trespassers. They have no right, and the construction company got a license to enter the land to do the construction work. They tried to sue the trespasser, and that in that case, the trespassers relying on this traditional concept that, being a licensee, you have no proprietary right, so you cannot eject us. But the case went all the way to the House of Lords, in fact, where the House of Lords confirmed the judgment of the Court of Appeal that as compared to trespasser, the licensee, even though they have not occupied the land, they still have the right to eject the trespasser. And just 2 more slides, so let's finish this and take a break. License is coupled with an interest. The license would be irrevocable as long as the interest still subsists. Now, for example, you have a contractual right to pick strawberry, or if you go to the new territories, and nowadays a strawberry farm or lychee farm, you purchase the rights to pick strawberry or lychee, then you would have a license to enter that farm, as long as you have not yet started picking up or picking the strawberry or lychee. The owner of the farm cannot stop you from entering the farm. Now, this interest, which allows a person to take something from land belonging to another, is different from the description I'm saying here. Because that we have a special term to refer to that right, to enter certain person's land to pick something that is called a porfit prontor, in our legal jargon, but this is not really in your syllabus. Just tell you in passing. And one last point to note is that a license, it will usually lapse if the licensor dies. So if someone grants you a license to enter or occupy certain land, if that person dies, usually your license will also lapse. That means lose any effect. Whereas a tenancy is not affected by the death of the landlord. So that's the end for lease. These are the important concepts that you have to know in relation to lease or tenancy. Let's take 15 minutes break, and when we come back, we'll look at the most difficult chapter,